This defense is and has always been about high risk, high reward. Accusations of witness intimidation and demands for a mistrial make for a dramatic week as a Massachusetts woman begins her defense against charges of murdering her police officer boyfriend. Plus, allegations of abuse, exploitation, and unhinged behavior continue to pile up in the federal RICO prosecution of a hip-hop mogul. And the final chapter begins in the years-long multi-state prosecution of the so-called Doomsday Mom. All this and more this week on Courtroom Confidential. This week was jam-packed with courtroom drama at its absolute finest. We are recording this episode on Friday, June 6, 2025, and this is your Courtroom Confidential Weekly Roundup. Let's jump in. Massachusetts woman Karen Reed's murder retrial resumed Monday as it entered its 7th week, with the defense now in full swing. Reed is accused of intentionally backing her SUV into her Boston police officer boyfriend, John O'Keefe, and leaving him to die in the snow outside fellow officer Brian Albert's home in January of 2022. Reed's defense alleges that O'Keefe was killed during a fight inside Albert's home, then dragged outside and left in the yard. Her attorneys say that O'Keefe was bitten by Albert's dog during the fight. Former Canton police officer Kelly Dever testified this week that she was on duty the morning John O'Keefe's body was found, though she was not part of the investigation. Dever had previously told the FBI she saw ATF agent Brian Higgins and then Canton Police Chief Kenneth Berkowitz standing near Reed's SUV for a wildly long time in the Sallyport at police headquarters. On the stand, however, Dever said she later retracted that claim after being shown a timeline proving she left work before the SUV arrived. Dever then accused the defense of trying to pressure her into lying, telling attorney Alan Jackson, quote, "You threatened to charge me with perjury during our phone call prior to the first trial if I didn't lie on the stand right now." Reed denied the claim outside the courthouse, saying, quote, "We subpoenaed her to testify to what she told other authorities and just wanted her to be as honest with us as she was with them. And today she's now telling us that was a lie." Next, the defense highly anticipated dog bite expert, emergency physician and forensic pathologist Dr. Marie Russell testified over the course of 2 days this week. Dr. Russell told jurors she believed O'Keefe had injuries consistent with a dog attack and inconsistent with a vehicle on pedestrian collision. During cross-examination, however, prosecutor Hank Brennan asked Russell whether she knew O'Keefe's clothing had been swabbed for dog DNA, prompting an immediate sidebar from the defense and heated 30-minute argument outside of the presence of the jury. Defense attorney Robert Alessi moved strongly and vigorously for a mistrial, accusing special prosecutor Brennan of intentionally introducing the topic of DNA. Quote, "There has been no mention in this trial of DNA with regard to what Mr. Brennan has raised. There has been none." Brennan responded that the absence of dog DNA may be inconvenient and hurtful, but not improper. The prosecutor also highlighted that Russell spoke about the absence of dog DNA and why she disregarded it from her analysis during pretrial hearings. Judge Beverly Cannoni ultimately denied the mistrial request and ruled that the prosecution could question Russell about the absence of canine DNA. Next, Dighton Police Sergeant Nicholas Barros testified Tuesday about the condition of Reed's SUV before it was seized on January 29th of 2022. Barros told jurors he observed taillight damage at the time, but that it appeared less severe than what was later shown in evidence photos. And finally, Brian Lucky Logren, a Canton snowplow driver, returned to testify for the second trial, again describing how he passed 34 Fairview Road 3 times between 2:40 a.m. and 6:15 a.m. Logren told the jury he did not see a body lying in the snow. However, under cross-examination, prosecutor Brennan pressed Logren on his recollection of events, including visibility conditions and his interactions with investigators. The plow driver ultimately admitting to timeline discrepancies from his earlier statements, blaming memory loss issues. Reed is facing charges of second-degree murder, manslaughter, and leaving the scene. If she is found guilty of the most serious charge of second-degree murder, she could spend the rest of her life in prison. What's happening here? This defense is and has always been about high risk, high reward. They did not take what many would consider to be the safe and cautious defense in this case. And in fact, what 9 out of 10 defense attorneys would have taken in this case. And that is simply to attack the idea of reasonable doubt, to say, listen, the prosecution has not proven anything to you. The prosecution has not proven that a collision took place. The prosecution has not proven that my client was involved. And most importantly, the prosecution has not proven the idea of intent. Intent has always been the weakest part of the prosecution's case, but intent hasn't even really been an issue for this defense team. That's because they have decided to take the high risk, high reward strategy in this case. And that is not just saying there's reasonable doubt, not just saying that a collision didn't take place between a vehicle and a pedestrian, but saying something else far more complex and far more sinister was at play. Instead, they are saying that it's a conspiracy, a cover-up, dog bites, planted evidence, crooked cops. If we were playing cards, we would call this shooting the moon. It's an all or nothing strategy. But along with strategies like this that can bring a high reward, in other words, you're not shooting for something like a lesser included crime. You're shooting for an absolute acquittal. Along with that comes risks. And we have seen some of that play out this week. The defense with Officer Dever calls a witness that they know will not be friendly to them. And for arguably little benefit, for the idea that she at one point told federal investigators that she had seen important players in this case around the SUV for what she described as a wildly long period of time. And this is the defense attempt to start to plant the seeds of that cover-up, of that conspiracy. I understand why they would like it. I understand why they would want the jury to hear it. But is this officer really going to give that to them? Then we realize that this officer had actually retracted her statements, that she had been shown evidence that convinced her that what she remembered was inaccurate. And she tells the defense this. The defense knew this going in. They knew how this officer was going to behave, how she was going to react, but I don't think they thought it was going to be this bad. This risk, in my view, did not pay off. When you've got a witness on the stand who's accusing the defense of trying to manipulate witness testimony, of saying that they were threatened with perjury if they didn't get up and lie to the jury, and they're saying that right now in front of this jury, they're refusing to do that, to put that mildly, that's not a good look. Let's now talk about the dog bite expert. A lot has been writing on this witness. Again, this is the idea of convincing the jury that it's not just that those injuries are not consistent with a vehicle on pedestrian collision, but that it's something else. They're offering a theory. They're taking that high risk, high reward strategy and saying, not only is this inconsistent with a vehicle on pedestrian collision, what it is a dog bite. And we'll tell you how that's important. So of course, the prosecution gets to cross-examine this witness about anything to do with evidence that might be consistent or inconsistent with the theory that this is a dog bite. The idea that no canine DNA was found on John O'Keefe is going to play a very important role in that expert's opinion. And the fact that she disregarded that, was able to look past that, is something that the jury needs to hear. This mistrial request, though I understand it, and I think it was necessary for the defense to make, the judge also got it right. Listen, guys, you open the door. You're presenting to this jury for the first time the idea about a dog being involved in this case at all. The prosecution didn't bring that in. The prosecution doesn't have to bring that in. The prosecution has no obligation to preemptively confront, to preemptively rebut potential defense theories. And that's exactly what Hank Brennan said in this case. If they want to bring that up, they want to talk about dog bites, they want to talk about planted evidence, they want to talk about fights and brawls and whatever took place inside the basement or wherever it was inside of that house, let them do it. I don't have to bring any of that up in my case in chief. And he didn't. And now we have this idea about dog bites, and he gets to cross-examine thoroughly on what evidence this expert did or did not consider. So the judge made the right call here. Now, I can already hear you all saying, oh, but the defense doesn't have to prove anything. What are you talking about? They have to prove something, or they have some sort of burden. You're absolutely right. No burden has shifted here. The defense does not have to prove anything. The defense can, and this is explained to them, sit on their hands through the entire trial. They don't have to call their own witnesses. They don't even really have to cross-examine witnesses. The burden is and always remains on the prosecution to prove beyond a reasonable doubt what they're saying Karen Read did. But I'll tell you this, when you start to posit theories to jurors, when you start to tell them that, no, it's not that the prosecution can't prove something, it's what they're trying to prove is wrong, and we will show you what took place. That's where you begin to assume some burden. Not legally, not strictly, not according to the law, but according to what's taking place inside of the jurors' minds. You begin to give them options and choices that they might feel are binary. If they don't feel this is a dog bite, do they then feel it must be a vehicle that caused those injuries to John's arm? And that is what you get with a high risk, high reward strategy. One note about this plow truck driver. He was one of two witnesses who I do think helped the defense this week. And it's not so much the idea that you can say he proved that John O'Keefe's body was not on the lawn when the prosecution says it was, because they're trying to prove a negative. They're trying to say, hey, because this driver didn't see something, therefore it didn't exist. And we all know that's not how it works. There could be any number of reasons why he did not see a body on the lawn. It could have been covered with snow. You ever live somewhere where it snows heavily? You know how that can blanket things and obscure the size and shape of objects. It could be that he was paying attention to his driving and just not looking at the lawn. It could be any number of things to explain why he didn't see something. The fact that you didn't see something does not prove that that thing does not exist. But it is powerful because it is an independent witness found by the defense that says evidence that the prosecution is saying existed was not witnessed by this person. That does have value. The defense went out and found this man, not the prosecution. I think that might even have the most value about this, that the defense was out, quote unquote, searching for the truth. They found this man, they put him on the stand, and he says something that calls into question the prosecution's theory of this case. That alone may be powerful. And the other witness was Officer Barros. Why? Again, because who he is. He's a cop. I felt he came across very honest. Just like someone trying to say things he witnessed. Someone who doesn't really have an objective, an end goal in any of this, but to tell the truth as a witness. Yes, he did concede that perhaps his memory is not as accurate today as it had been in the past. He did admit that he didn't take extensive notes about the damage that he saw to the vehicle, but he was emphatic about the damage that he saw not being consistent with photos and evidence. All of this being said, the defense case really begins with the ARCA experts who are soon to come. Those accident reconstruction experts are going to be, I think, the make or break point in this high risk, high reward strategy of the defense. But what do you guys think? Who is the strongest witness for the defense this week? Please let us know in the comments. Week 4 of Sean Diddy Combs' federal sex trafficking and racketeering trial began with the third day of testimony from a former assistant of Combs known only as Mia, testifying under a pseudonym. Over 3 days, Mia described verbal, physical, and sexual abuse she said she endured while working for Combs. Under cross-examination, Mia acknowledged she never reported the alleged abuse to law enforcement or asked anyone else to do so. A hotel security guard testified Tuesday that Combs paid him $100,000 in an attempt to secure his silence and bury surveillance footage showing Combs assaulting his ex-girlfriend Cassie Ventura in a Los Angeles hotel hallway in 2016. The video, now central to the government's case, has been shown to the jury during multiple witness testimonies. The guard, Eddie Garcia, said Combs was desperate to keep the footage from surfacing. Quote, "He was concerned this video would get out and it would ruin his career," Garcia testified, adding that Combs called him Eddie my angel after saying that he would accept $100,000 in exchange for what Combs thought was the only copy of the recording. Prosecutors argue that Combs' $100,000 payment to the hotel guard was a bribe and part of a broader racketeering conspiracy meant to conceal years of abuse and criminal conduct. They allege Combs used his business empire to facilitate sexual exploitation and protect his image. Next on the stand was Brianna Bonglin, a friend of Ventura's, who described a 2016 incident in which Combs allegedly dangled her over a 17-story balcony while repeatedly yelling, "Do you know what the F you did?" before throwing her onto balcony furniture. Bonglin said she didn't know what he was talking about. She suffered bruising and neck pain and continues to experience night terrors and paranoia. She also recalled a 2016 beach photo shoot when Combs allegedly got in her face and said, quote, "I'm the devil and I could kill you." When asked why she continued to see him after that, she responded, "Honestly, I don't know." The third and final alleged victim to testify against Combs, a woman being called Jane, is expected to take the stand late this week and testify for as long as 5 days, according to prosecutors. What's happening here? I first want to talk a little bit about this videotape. This is incredibly powerful evidence, and we know that because of what Sean Combs was willing to pay, $100,000 to make sure this didn't get into the wrong hands. Now, that obviously did not work out well for him, but even he knew whatever was captured on this video was something that was going to be incredibly impactful if it was ever shown in a courtroom one day. And it is. And it is a central piece of evidence to the government's case. But they risk, I think, diluting that impact or desensitizing the jury to it by showing it too much. I speak from experience. Having been a prosecutor in a case where videotape did play a central role, I learned that showing it to the jury too much simply made it another piece of evidence, something that they could analyze frame by frame, something that didn't have that same visceral impact that it does when you first watch it. Just a note that I thought might be a concern for prosecutors to not use that or overuse that videotape in this case. I think we have to be honest and admit that standing on their own, independently, many of these witnesses have issues. Why do they keep coming back? If they suffered this kind of abuse, why do they continue to return to their abuser? Even when presented with opportunities of escape, why do they continue to come back? Why do they send him text messages and other types of communication expressing something completely diametrically opposed to what they're now saying on the stand? Now, sure, an expert can explain all that and talk about the cycle of abuse and how people can be brainwashed into believing that somehow it's their fault. I understand all of that, and I think that the prosecution is addressing that head on. But still, it's going to be hard for a jury to reconcile when these witnesses are considered independently. But these obstacles become less problematic when you hear witness after witness telling remarkably similar stories of abuse and unhinged behavior. Because what happens then they start to cross-corroborate each other. Then it's not just each witness in a vacuum, each witness independent. Even though the law requires each witness, each victim, each crime to be considered independently, jurors do what we all do and start to say things like, what are the chances? What are the chances that one person would tell about remarkably similar events to another person that they seemingly had no connection to? And do these stories then begin to take on a deeper understanding that, yes, this abuse did take place? Has the prosecution proven crimes in this case? I think we can all comfortably say yes. But again, we have to go back to that question of, have they proven a criminal enterprise? The prosecution's own theory on this is that Combs used his business empire to facilitate sexual exploitation and protect his image. My question is this: how is that different from any other powerful abuser that we have heard about? Right down the street in the city of New York is Harvey Weinstein on trial again. And he's on trial in state court. And it's not a RICO case. It's not a federal case. And what's the difference there? In Weinstein's case, prosecutors are saying that he has used his power, his influence, threats, all to accomplish the goal of control, sexual exploitation, and protecting his image. Does that sound familiar? Is it just that it's more in the case of Sean Combs, or more extreme, or more victims? But isn't that just a question of a difference in scope and not in kind? This is no small question. The difference here between the RICO allegations being found true or not is the difference between him spending the rest of his life in prison or not. And so I'm not saying that the prosecution is completely out of its depth here, but they still have a ways to go, at least in proving to me as to why this case is different from other cases, why this case involves racketeering and criminal enterprise, where in other cases, we're just talking about an individual serving their own needs. But what do you guys think? What do you think makes this case different? What, in your view, makes this a racketeering case? Please let us know in the comments. Despite unexpected delays, jury selection resumed Wednesday in Doomsday Mom Lori Vallow Daybell's latest attempted murder conspiracy trial in Arizona. On Monday, Vallow Daybell was brought into court in a wheelchair, pushed by a deputy, telling the judge she has a terrible headache, nausea, and chills. Despite her complaints, Judge Justin Boreski decided that jury selection would continue, explaining that he was not provided with any objective medical information as to why Vallow could not proceed, and that while she had a headache, she otherwise appeared to have a sound mind and was able to advocate on her own behalf. Ultimately, on Wednesday, 16 people were selected, 8 men and 8 women. 12 will deliberate and 4 will serve as alternates. Vallow Daybell is facing a murder conspiracy charge out of Gilbert for allegedly conspiring to kill her niece's ex-husband, Brandon Boudreaux. Investigators believe Vallow's brother, Alex Cox, shot at Boudreaux outside his home in Gilbert back in October of 2019. Boudreaux was not hit or injured, but a bullet shattered his car window while he was driving. During opening statements, prosecutor Trina Kay described for jurors how Brandon Boudreaux was driving home when he noticed a Jeep with Texas plates parked near his driveway. He then saw the back window of the Jeep open up and a rifle barrel pointed at him before, bang, his window shattered. Kay told jurors, quote, "In the back of that Jeep was this defendant's brother, Alex Cox, who had been lying in wait with a rifle for Brandon to return home." Vallow began her remarks by telling the jury that the prosecutor and police were not there when the alleged shooting took place. Quote, "Their job is to make up a story and fill in the gaps." Later adding, quote, "In this case, you will hear a lot of speculation. During this trial, the state will try to convince you I committed this by using speculation and innuendo." The first prosecution witness was the named victim, Brandon Boudreaux. Boudreaux told jurors how his previous wife, Melanie, who he shares 4 children with, is also Vallow's niece. Boudreaux then began to describe the increasingly troubling relationship between his former wife and the defendant. Boudreaux's testimony is continuing as of this recording. Vallow was previously convicted in Idaho and Arizona on a slew of charges, including the deaths of her children, Tylee Ryan and JJ Vallow, and her husband's former wife, Tammy Daybell, and conspiring to kill her former husband, Charles Vallow. Vallow, as in her first Arizona trial, is representing herself. What's happening here? Well, let's first consider the issues that the prosecution is going to have in this case. First of all, it's a conspiracy case. Those cases are always difficult. You have to show agreement. You have to show agreement ahead of time. You can't just show benefit. It's not just, did someone benefit from this murder, but did someone agree to and take steps in furtherance of committing this crime ahead of the crime being committed. That's always going to be difficult, but it's even made more difficult in this case because one of the co-conspirators, in fact, the trigger man, is not here. He has passed away. Alex Cox died before this trial is taking place. So there's no co-defendant. There's no person to point to as being part of this conspiracy. And there's someone who's not present in court for the current defendant, Lori Vallow, to blame everything on. Let's talk a little bit about the strengths, though. The victim in this case is thankfully still alive. He was not killed, and he can tell about what happened. He can provide context. He can connect the dots for the jurors. That, I think, will be very powerful in this case, and no wonder that the prosecution is calling him as their first witness. And then you have the issue of Lori Vallow herself, again representing herself, again motivated by this incredible ego and narcissism, these complaints of illness, this childlike behavior. Even in the hands of a very skilled lawyer, this would be a difficult case, but in the hands of someone like Lori Vallow, who is simply untethered to reality, it's going to be nearly impossible to mount a defense. But what do you guys think? Is this finally and thankfully the last chapter in the Lori Vallow Daybell saga? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to stop for a moment and ask that you do me one very small favor, and that is, if you haven't already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way we can do that is through your support. And please don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, once again, the fate of a disgraced former movie producer rests in the hands of a New York jury, a year after his first conviction was overturned. In closing arguments Tuesday, prosecutors urged the jury to convict Harvey Weinstein of rape and sexual assault, portraying him as a powerful predator who used his influence to lure and abuse women. Assistant DA Nicole Bloomberg called Weinstein a serial predator who promised Hollywood success only to trap women in private settings and assault them. Quote, the defendant used his power and influence to create many award-winning movies, Bloomberg said. But he also used that same power, that same influence, to isolate women, trap women in places where he'd be alone with them and abuse them. Weinstein, now 73 and appearing in court in a wheelchair, is on trial in Manhattan for the second time after his 2020 New York conviction was overturned in April of 2024. The prosecution built its case around three star witnesses, Miriam Haley and Kaya Sokola, who Weinstein is accused of sexually assaulting, and actress Jessica Mann for a more serious charge of rape. Weinstein's lawyer accused the three alleged victims of lying on the witness stand out of spite after consensual sexual encounters with the movie mogul failed to deliver them Hollywood stardom. Defense attorney Arthur Aidala told jurors they are lying about what happened, not about everything, but about a small slice, just enough to turn their regret, their buyer's remorse, into criminality. If convicted, Weinstein faces up to 29 years on top of the 16-year sentence he's already serving in California. Trial for the man accused of killing and dismembering a woman after their first date continued into its second week in Milwaukee County Circuit Court. Maxwell Anderson is charged with first-degree intentional homicide, mutilation of a corpse, hiding a corpse, and arson in the April 2024 death of Sade Robinson after they went on a first date in Milwaukee. Earlier this week, jurors heard Anderson's former tenant, who testified to hearing Anderson bring something downstairs just days before a SWAT team raided the home on April 4th. Jurors also saw the last known footage of Sade Robinson alive, leaving Dukes on water with Anderson around 9 p.m. on April 1st. A search of Anderson's home uncovered a red plaid jacket seen in surveillance, the shirt he wore that night, and 51 knives, though no physical evidence directly tied to Robinson was found inside. A couch seen in photos with Robinson tested negative for blood. Investigators also walked jurors through surveillance footage and cell phone data tracking Robinson's car after he left Anderson's home in the early morning hours of April 2nd, 2024. Footage showed the car heading toward Warnemont Park in Cudahy, where prosecutors say it crashed through an access gate to the lake. A shadowy figure appeared in the video. The same day, Robinson's leg was discovered at the park. Later at 4:40 a.m., surveillance video showed the car passing the St. Francis Police Department, coinciding with the moment Robinson's phone went dark. Her car was not seen again until it appeared near 27th and Wells, circling the neighborhood for more than 2 hours before it was set on fire. A person was seen walking away from the burning car, and Anderson was later captured on video boarding a bus at 35th and Lisbon, heading back home. Last Friday, a famous British actor, comedian, and podcast host pled not guilty to rape and sexual assault charges involving 4 women with allegations dating back to 1999. Appearing in London's Southwark Crown Court, Russell Brand denied 2 counts of rape, 2 counts of sexual assault, and 1 count of indecent assault. Prosecutors allege the incidents took place between 1999 and 2005. Among the allegations, Brand is accused of assaulting a woman at a hotel during a 1999 Labour Party conference, attempting to drag another woman into a men's restroom in 2001, attacking a 3rd woman at a party in 2004, and groping a 4th woman at a radio station between 2004 and 2005. Brand arrived in court dressed in black and holding a copy of The Valley of Vision, a collection of Puritan prayers. When the charges were announced last month, Brand said he welcomed the opportunity to prove his innocence. Quote, "I was a fool before I lived in the light of the Lord," he said on a social media video. "I was a drug addict, a sex addict, and an imbecile. But what I never was a rapist. I never engaged in non-consensual activity. I pray that you can see that by looking in my eyes." Brand's trial is set for June 3rd of 2026 and is expected to last 4 to 5 weeks. A Michigan man charged with the murder of his wife, first reported missing in 2021, whose remains were not discovered until 2024, was back in court for several motion hearings. Dale Warner, charged with murdering his wife Dee Warner, appeared virtually last Friday as part of an ongoing pretrial proceedings. His jury trial, originally set for September 2nd, was rescheduled to January 27th of 2026 to accommodate his defense attorney. Judge Michael Olsaver addressed several motions, including the defense's motion arguing that key text messages, particularly those from Dee Warner's brother Greg Hardy, were missing, accusing the prosecution of selectively providing records. Although prosecutors responded that they have turned over all of the evidence, the judge granted the defense's request to have a hearing to examine whether any additional information exists or previously existed. The defense also argued that Warner's Fourth Amendment rights were violated when police and prosecutors listened to his jail calls without a warrant. Attorney Mary Sherrier claimed that since Warner could not afford bond, he was unfairly left vulnerable to surveillance. If he was wealthy and had the money to bond out, she said, this predicament wouldn't exist. Judge Olsaver disagreed, but did concede that the defense is entitled to access all of Warner's calls to prevent selective use by the prosecution. The issue of social media content also became an issue, particularly posts on the Justice for Dee Facebook page. The defense highlighted a post detailing how to become a, quote, shadow juror, and claimed the content inflamed local opinion and tainted the jury pool. The judge acknowledged troubling content online, but said he wasn't convinced it rose to the level requiring a venue change yet. He left the door open for the issue to be revisited and said tools like early juror questionnaires could help assess impartiality. Dee Warner was reported missing in April of 2021. Her remains were found in August 2024, sealed inside an anhydrous ammonia tank on property owned by her husband, Dale Warner, about 4 miles from their home. The discovery followed more than 3 years of searches and investigation. Meanwhile, charges against Warner's son, Jaron Warner, who was initially accused of tampering with evidence and being an accessory after the fact, were dropped earlier this month after a key witness became unavailable. Prosecutors said the charges may be refiled if the witness is located. On Thursday, a Florida woman was sentenced to 36 to 90 months in prison after pleading guilty to conspiracy to commit murder in a plot to have her husband, the star of the reality show Ghost Adventures, killed. Prosecutors say Victoria Goodwin conspired with a Florida inmate, exchanging texts and Facebook messages about her husband, Aaron Goodwin's whereabouts and how she would pay for the hit. Police reports stated that Victoria was in love with the Florida inmate she had been texting with, convicted murderer Grant Amato, who she contacted in March 2024 after seeing him in the Paramount Plus true crime docuseries Control Alt Desire. Amato shot and killed his father, mother, and brother after stealing $200,000 from his family to fuel his online addiction to a webcam model whom he met through a pornographic website and became infatuated with. He was sentenced to 3 prison terms of life without the possibility of parole. Victoria Goodwin denied that she wanted her husband to die, arguing that she was only daydreaming. She was arrested on March 6 and pleaded guilty in late May in exchange for prosecutors dropping a solicitation charge. Aaron Goodwin filed for divorce days after his wife's arrest, later accusing her of assault and false imprisonment. He's seeking more than $10,000 in punitive damages. A Colorado man was sentenced to life in prison Monday for killing a young woman by throwing a landscaping rock at her car, smashing her windshield as she drove in Jefferson County, Colorado in April of 2023. Joseph Koenig was convicted of 19 charges, including first-degree murder, attempted murder, third-degree assault, and attempted third-degree assault in connection with the 2023 death of Alexa Bartel. A judge sentenced him to life in prison without parole, plus an additional 60 years to be served consecutively. Approximately a week after Bartel's death, police arrested Koenig, as well as Zachary Quack and Nicholas Carroll Chick. Both Quack and Carroll Chick pled guilty, accepting deals with the prosecution that required them to testify against Koenig at his trial. Carroll Chick was sentenced to 45 years and Quack received 32. Quack told jurors the trio collected rocks from a median area along the road and began throwing them at cars. He described Koenig throwing shot put style with his dominant left hand. Alexa Bartel's parents tearfully delivered their impact statements at Koenig's sentencing, saying she was stolen from them. Her father said he'd give Koenig the death penalty if he could, and her mother said Alexa's death shattered her. Koenig said that he had 2 years to think about what he wanted to say before apologizing to Alexa Bartel's family at his sentencing hearing. Koenig acknowledged it was his fault Alexa is gone. Before we get to what's on the docket for next week, I wanted to take a moment to thank you all so much for being a part of our growing Courtroom Confidential community, but I wanted to give a very special shout out to Bunny Bella 765 for their fantastic review on Apple Podcasts, as well as to our CC crew members Chihuahua Mama Life and Marta Fonda for their support on YouTube. Keep them coming. We absolutely love hearing from you, and please tell us where you are from. We are thrilled by the growth of our Courtroom Confidential community. San Antonio man Brad Simpson, who is accused in the disappearance and presumed murder of his wife, Suzanne Simpson, will be back in court Monday, June 9th for a status conference. Florida matriarch Donna Adelson, who faces first-degree murder and other charges related to the shooting death of her ex-son-in-law, Dan Markel, will be back in court twice next week. She has a case management hearing on Wednesday, June 11th, and a motions hearing on Friday, June 13th. Kevin Ellis, Catherine Rastelli, and Tracy Grist are scheduled for a pretrial conference on Wednesday, June 11th, in connection with the July 2024 shooting death of Matthew Rastelli, who was killed while picking up his wife, Catherine, at her mother's home. Ellis has claimed self-defense, saying Matthew threatened him with a knife, but investigators found the circumstances suspicious and ultimately charged all 3 with Matthew's murder. And finally, please visit us at thecourtroomconfidential.com for more information about our membership program and benefits, new merchandise, and to stay in the loop on exciting announcements we have coming up. And that is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.